achieve its goal. What happened to the $30 million that was transferred to the trust? Did the Federal Trade Commission get this money back? The FTC goes to the Cook Islands. They file a lawsuit against the trust company in the Cook Islands, and they say, give us the money back. And they lose. They go to New Zealand, the parent jurisdiction, file a lawsuit there, and they lose. Go back to the Cook Islands, file another lawsuit, lose again, and leave the Cook Islands. And the money is still sitting in the Anderson's Trust for their benefit. So even in these worst case, set of facts, where you have a super high profile case, you have a large government agency after you, there's a lot of money at stake, the trust still achieved its purpose. The money was unreachable. And if it was properly drafted, if the Andersons were not the trustee, they would have never done jail time for contempt of court. Okay? So these trusts, the foreign trusts, when you can transfer liquid assets offshore to a foreign bank, is really one of the only two structures that we have where we can tell a client your assets are protected 100%. With these structures, with the offshore structures, the money becomes unreachable by anyone other than the client. How much time do we have left? Oh, we have plenty of time. Excellent. A few commonly asked questions about foreign trusts. First, you want me to do what with my life savings? You want me to send my life savings to the Cook Islands? As far as I know, the bank in the Cook Islands is just some guy sitting under a coconut tree with a bag of cash. I'm not going to send my life savings, my retirement nest egg, to the Cook Islands. Well, no one has asked you to do that. I never said that your money is going to go to the Cook Islands. I said that the trust will be set up under the laws of the Cook Islands. All that we want from the Cooks, or from St. Vincent and the Grenadines, or from Nevis, are their laws. We do not want to necessarily send the money there. Where does the money go? Well, some clients keep the money in the United States in their bank or brokerage account here until there is a collection action, and then the money goes offshore. And some clients send the money offshore from the start, but the money doesn't go to the Cook Islands. It goes to a Swiss bank or a Hong Kong bank or a Liechtenstein bank or something like that. So the money is in a safe banking haven, and the trust is in a good trust law jurisdiction. Okay? And we get kind of the best of both worlds. The clients always, almost always inquire, well, isn't it possible that this trustee that you have, let's say in the Cook Islands, will run off with our money? Well, obviously anything is possible. We tend to work with trust companies for very long periods of time, many years, so we can trust them. They've done work for a lot of our clients, but obviously our clients do not necessarily have the same degree of trust. They don't know who these trustees are. They don't know this trust company like we do. So how can we offer our client this peace of mind? Well, the structure that has been developed is the following. We will set up a trust in, let's say, the Cook Islands. I'll continue using Cooks as an example. We'll set up the trust in the Cook Islands. And under the trust, we will set up a limited liability company, also in some foreign jurisdiction. And it will be this limited liability company that owns the bank account, let's say, in Zurich. How does that allow us to retain control over the actual money? Well, if the bank account is owned by the LLC, then who controls that bank account? Who has the signature authority on that bank account? It's the manager of the limited liability company. Who is the manager of the limited liability company? Well, it's our client. It's our client's spouse. It's our client's best friend. It's whoever our client appoints to be the manager of the LLC. And it's the manager and only the manager who can sign on that Swiss bank account. Okay? So the client has the asset protection because technically speaking, everything has been transferred to this foreign trust. But practically speaking, by incorporating this LLC into the picture and appointing the client to be the manager of the LLC, practically speaking, the client can keep control of the assets within the LLC. He does not need to worry about someone else running off with his money because he's the only one now who can run off with the money, because the bank is not going to take instructions from anyone other than the manager of the LLC. Okay, let's go to slide, well, briefly on the tax treatment of these offshore structures, which is on slide 16, and very briefly on the FBAR forms, it's something that's been in the news a lot lately. A foreign trust is subject to an IRS reporting requirement, meaning there is no additional tax you pay by having this trust. This trust, for income tax purposes, is what's known as a grantor trust. It is treated exactly the same way as a living trust for income tax purposes, with one difference, and that is you have to disclose the fact that you own this trust, that you have this trust, to the Internal Revenue Service. And it's disclosed, as you can see on the slide, by filing a Form 3520, initially when you set up the trust and transfer assets to the trust, and then each year thereafter you file Form 3520A. If you have a foreign limited liability company, you also have disclosed that company to the IRS, file, I believe it's Form 8858, and disclose the existence of this limited liability company to the IRS. If you have a foreign bank account, you have to disclose that foreign bank account also to the IRS. For our clients, none of these requirements are an issue because we are not doing this work for an income tax planning purpose. We're doing this solely for asset protection. So disclose this to the Internal Revenue Service. There is really, at least from an asset protection standpoint, there is really no downside to this disclosure. We are not trying to hide these structures from creditors. Remember what I said earlier. Privacy, secrecy, hiding assets does not work at the end of the day. We want to set up the kind of structure where the client tomorrow can get on top of the building and say, this is what I did, this is the structure that I set up, and the plaintiffs and the creditors still will not be able to penetrate that structure. And this is a perfect example of that. No one can get through the structure. So disclose, follow the IRS guidelines, your assets are still safe. Retirement plans is probably one of the bigger assets for many baby boomers, at least if they played their cards correctly. How are the retirement plans treated in the world of asset protection planning? Well, it depends on the state that you live in, and it depends on the type of retirement plan. There are certain types of retirement plans that are protected under federal law. So if you have a plan that is what's called an ERISA qualified retirement plan, something like a 401k plan, a defined benefit plan, money purchase plan, any plan that is ERISA qualified, meaning that when you transfer money into the plan, you get an income tax deduction and then a deferral. It's usually ERISA qualified. Your money sitting in this plan is fully protected under federal law with no exceptions. I mean, the protection under federal law is so strong that you can almost literally rob a bank, walk across the street to your plan administrator's office, make a contribution to the plan, and the bank will not be able to get the money back. I'm not suggesting you do that, but it's an illustration of just how strong the protection of an ERISA plan is. There are a lot of retirement plans that are not ERISA qualified. For example, an IRA, any type of an IRA, a Roth IRA, SEP IRA, a regular IRA. These are not ERISA qualified plans, and there is no federal protection for IRAs. Here the protection varies from state to state. For example, if you live in Florida, your IRA is protected. If you live in a state like California, the IRA may be protected. There is a subjective standard that the court uses to determine whether or not your IRA is protected. They look at things like what other assets you have available to you for your retirement needs. They look at how old you are, what your earning potential is, all to make the determination of whether or not you need the money in the IRA to provide for your retirement. Okay? So generally the planning with retirement plans is that if the client has an ERISA plan, you're done, there's nothing else you need to do. If the client has an IRA, then depending on the state, maybe you need to do something. Let's say the IRA is not protected in the state that you live in. What do you do? Well, there are two options. You either roll the IRA over into an ERISA qualified retirement plan. Let's say the client has an IRA, and at work he also has a 401k plan. 401k is ERISA qualified and protected.